Hi, this is Kailas Kafle, and I'm representing group number 45 for our group presentation of corporation law. And so, yeah, and it goes like this. So, to start the presentation, first of all, we'd like to talk about the introduction, and so these are the main points which are highlighted in the assignment as well. So, the main statutory regime which has been created for corporate governance and is implemented is undertaken by the Corporation Act. The major identities which are incorporated in this particular act are companies and different other corporate bodies. The different aspect that the act deals with includes reports, members, disclosure, etc. These factors are entities which help in creating the overall mission and values of the given firm. They also aid in planning, developing, as well as assessment function of an entity. So these are the main highlighting point as an introduction for the assignment that we have prepared.
My name is Karuna Thapa and I am representing assignment group 45 and the unit code is HA3021. So I am here to give such presentation about to become the eligible member and shareholders of a small night limited company. So I will be showing you in my screen as well as I will be explaining you briefly. So here goes my first slide of the presentation, and in the second slide there will be some introduction part, but I am going to explain briefly about becoming a member and its eligibility, which will be in the third and fourth slide of my presentation. So there you can see a person named James who is very keen on purchasing the portions of a firm called SNL, and he is additionally keen on thinking about an assortment of things about the firm, like rules and regulations that individuals and partners need to follow, the degree of commitment that they have in the firm, as well as the length of their residency in the firm, and of course, their necessity to turn into a part. Similarly, the presentation would incorporate how the individuals are portrayed and the terms of enrollment as indicated by the Corporation Act 2001. And similarly, here goes my fourth slide. So here I will be discussing about the individual who may become a member of the firm if he or she registers with the same origin, and if someone wishes to enter the company at a later stage, they could sign up as a member and record their name. Likewise, an individual may become a member of the firm by not registering himself or herself in the first few years of the firm in accordance with Section 167. They would have to buy SNL shares. Nevertheless, certain orders may be left on the firm and its members by the court, and it may be the court's decision to decide whether or not they want a person to continue or suspend their position.
Hi, I'm Sanju Masranki-Bagar and I'm going to explain the rest of the part of becoming a member and its eligibility.
According to Section 237, a person will become eligible if only he or she was registered as a member, former or current office of the firm. In addition to this, even though there was some sort of agreement between the firm and a member, a public organization can easily remove a current member whenever they want, whereas a member also have full right to present their case in front of other member if he or she is comfortable with. In this section, it also says that whenever a company needs a better employee in any particular field, they can easily hire anyone whenever they want. Moving towards the another section, Section 5 and 6 of the Corporation Act 2001, there are some of the points that has been highlighted. Committing an offense in an organization will lead to an individual to the termination from the company. Provisions are not compiled to them, the firm will acquire a criminal or civil liability in the long term, which will result can be that either a person have to pay certain amount of charge, or he or she have to be in prison for 3 to 6 months. Eventually, in the case of Gore versus ASIC, Gore was convicted in the case and imprisoned for the same. Thank you.
Hi, it's Ms. Sagundep Kota. Here I'm talking about the procedure regularity. According to given case, James had observed that the director of FML didn't come for annual general meeting that he himself has set up so that the development strategy of the firm could be discussed. So here we can see James observed that he didn't come for the annual general meeting, so the development strategy firm could be discussed. And the second point is the absence of director comes under a procedural irregularity which has been identified by member of firm. The procedural irregularity could also be because of the irregularity of time that the director provided as the notice to other people. The third point, it is a breach that is made in terms of the conduct or responsibility which has to be undertaken by director of the firm. And the next point is the breach of this kind has been mentioned in section 1322 of the Corporation Act 2001. And finally, the last point is the procedural irregularity takes into account in the absence of director from meeting. Since the procedural irregularity, it is a breach that made in terms of conduct or responsibility which will be undertaken by the director of the firm. This kind of breach it has been mentioned in section 1322. So that's the end of my part of the procedural irregularity. Thank you.
Hi, I'm Sahil. My part is based on potential liability, where I'm talking about the case that is mentioned in the group assignment, where the Alan, who is the chief financial officer, has made a breach on the potential liability. Here, he kept his cousin as a tender for the renovation of his company and letting him know everything about the company demand in privately. Basically, the potential liability refers to the risk of being held legally responsible for something. Now I'm going to the presentation slide. Let's begin from 1317E. It is clearly mentioned that any officer could not benefit proportionally from the judgment that would come out in the term of breach of the liability. This kind of civil penalty is said to be contravention of Section 79 of the Corporation Act 2001. So similarly, in Section 82 of this Act clearly states that the both director as well as officers should not take advantage of their position for benefiting themselves. If any individual undertakes the breach of subsection 1 of section 82, then they would have an involvement in the contravention of section 79 as well. So I'm changing my slide. As we know that section 83 explain about the Allen is observed breaching the potential liability. In the next point it says that official and director must not keep any information hidden, as it can breach both Corporation Act as well as organizational constitution. I have figured out some cases that is belongs to this kind of act. So first of all, let's start from the case Camelot Resource Ltd VA McDonald's. Here it mentioned that the information should be all private. It is important for the company's beneficial. Similarly to the case Thomas Marshall Ltd v Junior, here no one means both the manager and officer should not make use of any information that could breach the Corporation Act for personal benefit. So Allen undertook a breach of section 191 and subsection 1 and 2 of the Corporation Act 2001. Also looking on the case Hall Pull Lamb, here we can find that Allen has breached the cases of honesty. Thank you.
Now we would like to conclude our presentation, and these are the main points which has been highlighted from the three cases given to us in the assignment. So to conclude, James is in a position to approach SML for any query or for buying further shares because he is a registered member. In the capacity of the secretary of the firm, we have advised James about how he can make other people become a member of the firm. The query about the terms of his director being late for the annual general meeting and the validity of procedural irregularity was also resolved. It was concluded that James could not claim any compensation for the breach of honesty. The report also discusses the case of Allen and how he should have been convicted because of non-disclosure of the information. So these are the main points that we would like to conclude the assignment from the three cases given to us in the assignment. Thank you.